Okay, evening all. Wherever you're joining us from tonight, welcome. I'm Helen Mills from the Centre for Crime and Justice Studies. I'm delighted to be chairing this event with a fantastic panel. You may notice that we have a chair on the end for a absent but not for much longer friend, and that is Dame Vera Baird. She's on the tube. We're expecting her around 6:20. So joint enterprise, as many people in this room and joining us online know, has been controversial and criticised for decades. Tonight we're going to be talking and reflecting with people who've been involved in many of the twists and turns of the journey so far, finding out a bit about where people think we've got to,
why this aspect of the legal system has seemed so resistant to change, and what realistic reform might look like. Bringing together this panel now is timely. There is a lot going on, as many of you will be aware. I'm going to be asking the panel about some of those recent developments, the recent referrals we know about from the CCRC on 2 joint enterprise murder cases, the political interest in narrowing the law, and a recent review by the Crown Prosecution Service of guidance on gangs evidence. This is very much a live issue. Our panel tonight is going to be bringing together law, research, lived experience, and institutional knowledge, often within the same person, and that mix is deliberate. I hope it's going to feel like a conversation. I'm delighted that we are joined in the room and online by people who've been directly affected by these laws and their practices, by families, lawyers, campaigners, researchers, law reform organisations and policy specialists. We've had around 140 people sign up for the event. Genuinely thrilled that we're able to be together tonight. So first step, I'm going to introduce our panel, who are known to many of you, but let me just say a line about each. So to my far left is Felicity Gerry. Felicity is a practicing King's Counsel barrister with over 30 years of experience. Complicity homicide is one of several of her areas of expertise. She was indeed representing someone currently who is in a joint enterprise trial. She was also, be known to many of you, as the lead counsel in the Supreme Court case that was successful for Jogee. To my immediate left, we have Charlotte Henry. Charlotte is a campaigner with Jogee. Charlotte is also a trained lawyer. She specialises in legal defence work. Charlotte's advocacy is shaped by her brother Alex, who was convicted for murder on the basis of joint enterprise in 2014. There was a piece in The Sun this week about it, and we can link to that in information that we have following tonight's event. For this, Alex remains in prison. To my right is Patrick Williams, Dr. Patrick Williams, scholar and academic. He is the co-writer and researcher with Dr. Becky Clark of Dangerous Associations, work that went on to become part of his prolific evidence-based interventions around racism, systemic harm, and the workings of the criminal legal system. His most recent work includes being an organizer of Harm to Healing Coalition, which is building a community-driven approach to justice. Hope you'll join me in welcoming our panel tonight. So format's pretty simple. I'm going to be asking some questions for about the next half an hour, and then we're going to go over to you, to audience questions. If you're joining us in Vauxhall and you're in the room tonight, you can ask directly. We'll take a few questions at a time. If you're joining us online, thank you for joining us. We'll make sure your voices are heard. There's a Q&A function that is in the Zoom room. Please could you use that to ask questions, and I will get wind of them. You can put those questions in there from the start of the event. You don't need to wait until we actually get to the audience questions bit. And I think there's also a facility there where you can upvote what's already there. So if there's someone's put something that you would also like to ask, please upvote it. Help us decide what we get to prioritize it. All right, let's get into it. I'm going to go straight into my questions, and I'm going to start with Patrick. We're 10 years on from Dangerous Associations, which was, as I said, your work with Dr. Becky Clark. This research that I think many of you know made the link between racist police practices and joint enterprise very visible. 10 years on, has that link weakened, do you think? Is it still there? And why do you think we're sat here tonight still talking about this?
First, thank you to CCJS, Centre for Crime and Justice Studies. 10 years ago, we sat in this space. Where's Richard? We sat in this space engaging in this work. I remember some of the characters who were involved in that work. There's Wilma Hahn, wasn't there?
Yeah.
Who was instrumental in that. And it's important for me to just remember that that work was probably initiated by, it was Jemba, or was at an event in Oxford with Jemba, who raised a question around why are so many of these cases that are coming in front of us, and at that time it was about 520 cases, JE cases. Many of them were making reference to this notion of gangs. And nobody had really explored that connection at that time. What we also found was that a number of these individuals, a vast majority of these individuals, were young black men, black and brown young men. And the question that was posed, and we had a funder, I should shout them out, Barrow Cadbury Trust, were willing to invest some resource in just beginning to explore that question. So Becky and I, alongside the Centre for Crime and Justice Studies and BTEG, Black Training Enterprise Group, sat down and began to do some reflection on what was taking place. And I think you're absolutely right. What we found was this powerful racializing discourse of the gang narrative, which was being attached to groups and individuals, which was being used to legitimize and justify the over-policing of children and young people within our communities. And there was something really important about teasing that out at that point, because we're probably just coming out of a moment where I think Lappy's report had not long dropped, had it?
It was just after. That's my next question, actually.
So we're shifting away from this narrative of, it was almost politically unpalatable to begin to talk about racism. People were shifting towards this narrative of bias, unconscious or implicit bias. People were shifting towards a notion of mistrust within the system as the drivers for. And for us, it was obvious when we saw the proportions and the numbers of individuals who were being ensnared by joint enterprise, that this was a racial tool, a racial dragnet, as people have said, which was hoovering up and dragging lots of young people into prisons. And let me just make a point here. In Manchester, where I'm from, between 2009 and 2016, 54 young people were sentenced to 749 years for 9 incidents. 749 years. Since that point, between 2021 and 2025, 35 young people have been sentenced to 534 years. 534 years. This is in the central Manchester area. It becomes extremely difficult to argue against, and predominantly these children are black and brown children. It becomes inconceivable for us to not accept, therefore, that this is a tool that was being used in black, brown, and working class communities and poorer communities as a way of responding to the so-called discourse of gang narratives and gang violence. And that became key for us.
Brilliant. I've heard some of those stats before, and I believe they came through Kids of Colour.
Kids of Colour, and many people in Manchester have been monitoring, but primarily Kids of Colour have been monitoring the numbers of individuals who've been ensnared and pulled into these cases. Absolutely.
Brilliant. And we're now just getting Vera mic'd up, and she's just joining us. You mentioned, Patrick, when you were speaking there, the Lammy Review. The Lammy Review came out, I think, just after that research was published, maybe a year later. It cited that research.
It did, yes.
And that is not the only thing that you've been giving evidence to. I think over the last decade, there has been multiple commissions, inquiries,
absolutely.
Expert evidence. Given those statistics that you've just quoted that are recent, very recent and ongoing, what does that feel like to have watched your findings be observed or absorbed by institutions and feel like, no, nothing much has changed?
It's a really difficult question, isn't it? It's a really powerful question as well. And I guess to the fore of that, I'm thinking about, again, not to just keep going back, families in Manchester who 10 years ago, their children were incarcerated through joint enterprise. And there's something about that length of time, I'm sat here looking at Jemba, I'm looking at, we're having these conversations all the time about the length of time and how nothing significant is shifting for children and young people. They're becoming older in prison. They were going in as children and they're becoming adults within prison. And it's really difficult because there's something about the pace of change. And if I was being forthright, my concern has been that we've often been drawn into legal arguments, and the legal practitioners are engaging in this discourse around, well, joint enterprise and whether it's this and whether it's that. But at the same time, what we have are children languishing, children, young people languishing in prisons. And that becomes my tension. The pace of change, and I'm not expecting things to shift overnight. What I do expect is to just acknowledge an injustice when it's taking place. Call out that injustice when it's taking place. Instead, what we're doing is gaining and falling into this haggling around, well, what is this? And how should it take place? And the legal practitioners are still respectfully, still employed and still doing what they're doing whilst those harms are still taking place. And I think it's important for us to acknowledge that in this space as well.
I am going to go to a legal practitioner now. Felicity, you're in a joint enterprise case today, right?
Yes, I'm not talking about that one.
You're not talking about that one. But forget the theory for a minute. How does it feel to you in a courtroom? Has much changed over the last 10 years? Are courtrooms feeling like the same as they were 10 years ago? Would you be saying the same things?
I think it's probably worse now than it ever was before, and I think there's an absolute failure to engage in what the UK Supreme Court were saying in Jogee, probably because it's not particularly well written. I hope I won't get disciplined for saying that, but also because we're against a background of a feeling of perhaps that the system is being attacked, so people get entrenched in their position. And I'll try not to bore you with too much history. I want to tell you stories, but I think there's a little bit of history that I found when I did Jogee that is really important to me. So bear with me and I'll try and do it quickly. For that case, we looked at 500 years of law and how the courts have grappled with secondary liability. So who is an accessory, particularly to murder. So I do murder trials. And when we reached that period of time when things sort of went wrong, when everyone talks about a case called Chan Wing Soo that happened in the Privy Council, it was a Hong Kong case, and the judge in the Privy Council got that case wrong, and he created this principle of foresight means if you foresee something, you authorise it. This case that later the UK Supreme Court said that was where it went wrong. It's not quite correct. It had gone a bit wrong before. People had got in a bit of a muddle because there was an effort to try and say, well, let's round up all these people and find a way to prosecute all these people, which you can see in the way the cases developed from the 1950s. And I don't think you can divorce from that people who were arriving in Britain in the 50s, which feeds into Patrick's work. So by the time we get to the 90s, you've got this one judge in the Privy Council that was only cited 2 cases and sort of made something up. And everybody grabs it and says, oh, that's a good way to prosecute these people. So this loose, off-the-cuff Privy Council judge is now adopted, and it becomes a much broader piece of law. And again, I'm not going to give a law lecture about it, but it's used as a way to round up a lot of people. And then we get to the 90s, and by this time, we then get to a case of Powell and English, which was an opportunity for the House of Lords, as then was, to rein everybody in and say, this is bad, actually. This is too broad. We're really convicting too many people. We've lost sight of the legal principles that we've had for 500 years. Instead, what the House of Lords said is, well, hang on a bit, this is quite useful. And I'm not making that up. It literally says, well, we know it's not logical, but let's give it a try. The word not logical is in the judgment. Let's give it a try is my interpretation of the rest of the decision. And what's really interesting is Jogee was an appeal in the Supreme Court with Ruddock, who came from Jamaica, who was represented by Julian Knowles, who's now a senior judge. And of course, he represented English, whose case was dropped at the last minute in the House as it was going to the House of Lords. And I think he had the point then. And it was 20 years later in Jogee, in Ruddock, that he got the chance to argue the point. It was never argued for English. And I always think it depends on the barrister being there to make the point. So we made it together in Jogee and Buddock, and it was important that we agreed, and we did. So in 1997, you've got the House of Lords saying we're going to keep this broad method and see how it works. And we know it was a disaster. And another thing happened was that the government abolished the proviso. Now, not many people remember the proviso, but it was a method by which the courts could say, well, we think you're still guilty, so we're going to something in your trial went wrong. We still think you're guilty, so we're going to uphold your conviction despite your trial going wrong. And there was evidence that those decisions were biased. So the Labour government abolished the proviso on the basis that judges couldn't then say, well, we still think you're guilty, so we're going to keep you there, this bias issue. And what I see in joint enterprise is really a method of getting around that. They're not allowed to say we still think you're guilty. But when you look at the decisions of the Court of Appeal made since Jogee and Johnson, for example, the test is effectively, can you prove you would not have been convicted under this old law? It's very, very close to we think you're still guilty, stay where you are. So I think the courts have deliberately found ways to round up lots of people. And that feeds into how trials are now post-Jogee. The idea that we've got to find a way to get round Jogee. Jogee's too complex. It's not hard. It's only hard because people who are not making a contribution to a crime are being prosecuted, and the system is trying to find a way to prosecute as many people as possible. And so I reached the point now where I did a principled case where their lordships recognised the law had gone wrong and were brave enough to say so. You have to recognise, super brave of the president to say the law's gone wrong and we're going to fix it. And then you've got a Court of Appeal since that has essentially publicly disagreed with the UK Supreme Court and found ways to still round up lots of people and prosecute them. And the language of simple tests for juries then loses that safe framework that we had for hundreds of years. And the jury has become a lottery without a legal framework. So you have to rest on the morality, if you like, of the general public to do the right thing. So how is it now? I think you hope to goodness that someone on the jury can work out that this is not right and this framework isn't enough, or there's something in this case that we've just got to be safe. So I don't think the system is safe at all. Everybody's at risk of being convicted. Essentially what we do is round up suspects, charge them all, keep them in prison on a threshold test, throw the suspects before a jury, and hope that the jury sort out the difference between a suspect and a criminal. Yeah. That's how it works now.
All right, there's several things in there that I think we're going to pick up on, and especially the point that I think both of you have sort of made around how far this has been reformed or can be reformed by law and courts, and how far it's taken to their body or parliamentarians to be involved. But before we go to that, I want to ask a question to Dame Vera, who's been able to join us after a longer tube journey than you were hoping for, perhaps.
Sorry.
Delighted you're here, and used to
in dry transport for them.
but you're here. Dame Vera, the CCLC have recently referred 2 joint enterprise murder cases to the Court of Appeal. Could you tell us a bit more about what the CCLC has been seeing in terms of joint enterprise cases more broadly, and what prompted those referrals?
I'm going to start by being really unhelpful. It's very important that I explain that there is a provision called Section 13 of the Criminal Appeal Act, which says that it's a criminal offence for a member of staff or a commissioner to disclose anything that they only know as a consequence of the exercise of the functions of the CCRC. So I won't be able to be specific about any case at all. I mean, I understand why it's there, I think, because our applicants are not our clients. So there isn't that bond of confidentiality and privilege that there would be if they were. And of course, we come into contact with a lot of very private information. So I understand it, but it is hell, because quite often, things are said incorrectly about CCRC and it's hard to reply. But yeah, we have, if I could go back to where Felicity was, and speak really probably as me, if you can imagine two people here now, less the CCRC and more myself. I do see that. I mean, I was in practice until about 2012, so all of my cases were pre-Jogee, and I did a lot of cases of joint enterprise murder and joint enterprise other things where it was just about, did that the person foresee? And it was, you know, incredibly difficult and plainly wrong. You know, that the person who uses the knife or whatever it is has to intend it, but I only have to perceive without necessarily being able to do anything to stop it or wanting it or let alone intending it. Very difficult indeed. So it, you know, for me in retrospect looked good when Jogee came on, and of course I now see people who are convicted pre-Jogee as of like Between the Devil and the Deep Blue Sea, because they were definitely, you know, with the devil, as it were, and now they are faced with almost, well, I suppose what they say is that unless there's a substantial injustice, they won't give they won't give leave to appeal out of time, and you can't come to the CCRC because there's a special legislative provision to stop that as well. And I see that to stop people going round, as it were, the Court of Appeal and coming to us. But a substantial injustice is not defined anywhere that I've ever seen to understand what it is intended to be. And it looks as if what they say, putting it you know, more legalistically than you did, not that I'm giving a law lecture after all this time, but I think they're saying, look, a jury's only ever had to decide, did the person foresee it? And they have decided, yes, they did. And now that's wrong. The law's moved on. And so nobody has ever decided whether they intended it to happen. And unless there is something to suggest that on the facts of the case, they wouldn't have been convicted because they would not have been proved to intend it, then oddly the wrong way around, there isn't a substantial injustice. But it does seem to me that's how it sits, you know, surprising as it is to say so. And even I think there is at least one case that says, if, assuming that the Court of Appeal think in this way, if somebody was convicted of murder and under the post-Jogee rule they'd be convicted only of manslaughter, that's not a substantial injustice, which, you know, is quite surprising, given, you know, it's a mandatory life sentence, you know, given, well, all of that indeterminacy. And so that's how I think they're Between the Devil and the Deep Blue Sea. And what the CCRC can only do is to look for substantial injustice as the as the criterion for referral. So it has to be looked at from that perspective. It definitely isn't an extra that we kind of load on, but you look for your reason why there is a real possibility that the case will be, that the conviction will be quashed through the lens, but looking at the facts of that substantial injustice position. So some of, I think we've sent 3, might have sent 4 actually, fairly recently. And they are, I think it's right to say, ones where it does look as if there is a substantial injustice, sometimes on the facts that were there, but sometimes on a new argument and new evidence that we found since. And some of those are related to the psychology or the psychiatry of the applicant, and some of them are related to other kinds of evidence that has newly appeared. And the Deep Blue Sea I mean, perhaps I should say this is for people post Jogee, but I guess it's something that still plays into the zeitgeist around all of these cases. But post Jogee, a real problem, which we have referred to about, is the gang narrative and the reliance on evidence that on the face of it isn't what I could call optimally admissible. It's not directly relevant. I mean, sometimes it is from an expert who's been involved in some gang-related police squadron for a long time. So you probably couldn't say that he wasn't an expert, but it looks to me quite often far more prejudicial than it is probative.
Mm-hmm.
And it definitely is, about pretty well imputing the intention to any member of the gang who makes the signs, who has the name, who wears the badge, who acts cool, and likes drill music, and calls people by nicknames related. It's almost there's that, and you prove now that you're not, somebody who is part of what is self-evidently a violent thing, a gang. One of the cases, which is a Manchester case, I think we were talking about Manchester, and I go back long enough to when Ross side was a fight between the Jogee and the Doddington, which were early gangs. That's long gone. But in one of those cases, well, there was so much evidence about the gang narrative and so much reference to it in the summing up that there is, I think, a very real possibility that evidence about how weak gangland can be, that it isn't self-evidently violent, that it's often about music and kids hanging around, that such evidence might play a possible role.
Okay, thank you for that. I want to come to Patrick on the gangs evidence, but before I do, I want to just turn to Charlotte, who knows a lot about the appeals process. For people who are currently in prison and think that they may have grounds to appeal that, what are the kinds of barriers and challenges they face to even getting that argument heard?
So firstly, I would say in order to apply for appeal, the grounds are incredibly narrow. So ordinarily, you need fresh evidence, and that evidence comes with its own kind of legal test under Section 23 of the Criminal Appeal Act. Or there needs to be something that happened at trial which was wrong. So, for example, the judge misdirected the jury. And to find those grounds of appeal, it takes an awful lot of resource. So to find fresh evidence, it might involve the tracing and interviewing of witnesses, the commissioning of experts, the post-conviction disclosure from the CPS, which I've been told is a nightmare. I've never dealt with it myself. And might also involve having to instruct lawyers because of the litigation that will inevitably come from that. And then to understand if anything particularly went wrong at trial. A lot of convicted people, they lose their legal team shortly after conviction, and so they go on the hunt for this secondary advice, and that's very difficult because there's a lot of lawyers that don't do appeal work because there is very much money in appeal work. If you're doing appeal work, you're kind of doing a lot of that for free, and so it takes a lot of resource, and people that are in prison, they don't have the resources at the end of their fingertips. So they won't have lawyers, and to be able to instruct a lawyer, well, you have to know who to instruct. You don't have access to the internet. It's very much word of mouth sometimes. And once you kind of identify a lawyer that might be willing to take your case, you've got to make that phone call. And you might not have credit, you might not have your case papers. There's, huge obstacles. Time itself is a resource, and time is not a luxury you have when you're trying to appeal a conviction. You've got 28 days from the date of conviction. But say you do, say, you know, you have the resources, you find a ground of appeal. The Court of Appeal has been roundly criticised for its approach. It's got a very restrictive approach when it deals with grounds of appeal, particularly fresh evidence. And that was addressed in the recent Law Commission report on appeals. And I'll explain my brother's case because I feel like it demonstrates that point well. My brother was convicted of murder in 2014 under joint enterprise. After conviction, he was diagnosed with autism by Professor Baron-Cohen, who's the leading expert in the field of autism, world leading. And he gave evidence to the Court of Appeal, and he told the Court of Appeal that because of Alex's autism, Alex has a theory of mind impairment, which means he finds it difficult understanding the emotions and intentions of other people and cannot predict their behaviours, or really struggles to predict their behaviours. And in Alex's case, the incident itself, which resulted in the murder, it was a spontaneous street fight between two groups of strangers, and it lasted 47 seconds. It was very fast moving. My brother was threw a punch at one person who was not the victim, and a mobile phone at another person. And so there was no evidence that Alex was told that there was a knife or knew of anyone's intent because the two groups were strangers. And Professor Baron-Cohen told the Court of Appeal it's to convict someone of autism in these circumstances. It's like convicting someone of walking into a wall to later find out that that person is blind. And for those of you that don't know, joint enterprise, the ability to understand or have the knowledge of the principal's intent and predict that the principal would go on to cause serious harm to the victim, that's a prerequisite of joint enterprise. It was a prerequisite of joint enterprise in terms of foresight in parasitic accessorial liability, and it's a prerequisite of joint enterprise today. And so what the Court of Appeal did in order to allow fresh evidence and allow the appeal, they have to consider under Section 23 of the Criminal Appeal Act whether the evidence is new, capable of belief, and relevant to the conviction. And unfortunately, devastatingly, they refused my brother's appeal. And they did so on the basis that they said the evidence was not new because Alex's trial solicitor hadn't given a good enough reason as to why Alex wasn't assessed before trial. And the second point was it wasn't capable of belief because although Professor Baron-Cohen is a world leading expert, my brother had been assessed by 7 psychologists between the ages of 9 and 14 because of behavioural issues. Those psychologists, you know, they weren't looking for autism in particular at all. We don't really know the level of their training. And this was in the 90s and the early 2000s. So our understanding of autism and diagnostically has completely changed. But nonetheless, they said that it wasn't capable of belief. That decision incurred criticism in the recent Law Commission report, which I was really pleased to read about, because the Court of Appeal shouldn't really be doing this. They shouldn't be saying, we don't believe this evidence, and so we're going to reject it on that basis. It should only be in situations where the evidence is wholly incapable of belief that you reject it on the basis. Otherwise, it really ought to go before a jury, because that remains in the province of the jury. It's their right to hear that evidence. But yes, so I'm really looking forward to the Law Commission's upcoming final recommendations to government to see what that brings us. But also, I'm really looking forward to seeing what they say on the substantial injustice test. So far, they've provisionally recommended that the substantial injustice test in its current form is abolished, but that's a provisional recommendation. So I'm hoping that carries through in the final report, which is expected this year.
Brilliant. And I know that those provisional recommendations drew on, I think, work that had been done by Jogee, yourself, and various other legal academics who've been advising Jogee.
Yes.
Okay. I know you came to this as a sister, but you then trained as a lawyer. I know you've drafted legislation. Seems like an incredible journey.
Thank you.
I'm interested, does training as a lawyer make you more optimistic about the capacity for change and reform, or a bit more kind of hard-headed about what some of the barriers are going to be?
Oh, that's such a difficult question. I don't know. I feel like with my personal experience, before what happened to Alex, I was probably how the general public kind of looks upon these issues. We've got the best justice system in the world. And so I've seen that. And now I'm a lawyer. I probably feel more hopeful about making change if you're resilient enough. It really, really needs like a dogged approach, resilience. I think we're all doing the right thing, and I think eventually we will get there, but to make change, you've got to build trust. For example, MPs aren't legal professionals, so you've got to kind of convince someone that doesn't quite understand what you're talking about, and get to the point with all of this amazing research, and I think we will get there, but I don't know if that's I don't know if that's changed from being a lawyer.
Yeah. Okay, good answer. Okay, I just want to touch on some of the things that we've spoken about so far, and then ask one more question about what people want to prioritise before we go into the audience question. Patrick, Dame Vera touched on gang evidence. I know that you'll want to say something about that. I also know that you were fairly recently involved with the CPS's consultation around their guidance on gang evidence. And so I wondered if what you may be hoping for out of that, or what you currently think of the current guidance and why it's being consulted about to be reviewed.
Yeah, there's a struggle around the language of gangs and the gang narrative, which probably falls back before I became involved in the joint enterprise work. It followed on from the EGYV strategy, Theresa May's strategy, in 2011, 2012, quite significant strategy, which was a response to the shooting of Mark Duggan and then the riots that took place. So the killing of a black individual in London led to a gang strategy, which then resulted in the criminalisation of more and more black and brown children. So I think it's an important point to make. I also think the reference to Gooch and Donington's a really interesting one, maybe a lad from Manchester, and recognising how that narrative was constructed within particular communities. And whilst violence may take place within particular communities, I would argue it's only in black and brown communities where that discourse is then shifted towards gang narratives. So it's in the presence of black communities that we will speak about gangs, whereby the same violence which takes place in other non-black communities is never defined and described as gang behaviour. We know across London that only, this is MOPAT figures, 5% of all homicides are thought to be gang related. We would never believe that by looking at the papers and the ways in which they frame black and brown folks as gang involved. So there's something really, we have to see the gang narrative as a resource, as a device. For this Nisha Waller's work, it's a conviction maximizing device. It increases the likelihood of hoovering up, and I'm saying the language hoovering up, not to be emotive about this, but just to recognize that we will get and convict more and more individuals by using the gang as a narrative. It becomes the intent. I'm a member of a gang. These are individuals who are members of a gang. And therefore, if one of those individuals commit the offence, then they're all implicated in this because they are one gang. It's Glory's line. When the jury see 5 young black people in a dock, what they don't see is 5 individuals, but one black gang. It becomes a really powerful tool. And I also think it's disingenuous not to place it on the jury, because the jury are also fed these narratives through a media that says that violence and young black men are hyper-violent and involved in gangs. It's extremely difficult for the jury to discern that within that moment, particularly when we have police officers who are also presenting that narrative that these individuals and these young men and these are involved in gangs. So there's a tension there. So I've always resisted throwing it on the jury, because essentially they're being presented this by police officers. I heard something fascinating the other day from some police officers who made reference to the fact that they have a 7-day target to try and identify individuals when there's a homicide. In the absence of charging individuals within that 7 days, then there's a knock on the door. Why are you not progressing this case? So they place pressure on the CPS. The simplistic way of gaining those arrests is, well, just arrest them all. There's 13 of them, there's 12 of them, they're all in a gang. And that sounds really simplistic, but it's really difficult for me to not make sense of what is driving. And that gang narrative is extremely powerful within that resource. So I just wanted to acknowledge that and just to recognise that the presence of gang units within particular communities, often Black communities, will drive the everyday behaviours of children. I've read some stuff and written reports where children stood outside a shop. The shop then becomes gang turf. The children go to that, play football on this park. That's their gang territory. It's remarkable how the presence of Black and brown folks becomes repurposed and reconstructed through this gang narrative. And I think it's important for us to begin to think on that. And just to the point you made reference to, we have to acknowledge the coloniality of some of this as well. It's remarkable that Jogee is also passing sentence on the killing of a man in Montego Bay. It's remarkable that we see joint enterprise used in Zimbabwe to suppress political activism and to ignore that these are the strategies and tools that are used within colonial settings, I would see as really problematic and a big mistake.
Felicity, let's bring you in here on the juries. Obviously, sometimes juries hear the evidence, and sometimes they may have heard evidence that ties someone to a case that is dependent on their supposed knowledge, on who they know. They may not have been involved in culpable acts of violence, and the law as it currently stands would not prevent you from being potentially convicted of homicide. But juries do hear that, and sometimes they acquit, and sometimes they don't, as they convict. Are there vulnerabilities that you're aware of in that you want to bring to our attention?
All right, so I'm going to put part vulnerability for a minute and just deal with the practical reality of a criminal trial. I think we can draw on what Patrick's just said. So when Jogee said foresight is not the test, as Vera has outlined, it said, but it might be evidence that you can be used in support of intention.
Yeah.
So the language that generally is used in criminal courts now is what did they contemplate? And what that does is draw in what are labelled inferences. And it's said to be reasonable to draw inferences of what young people, women, Black people, autistic people contemplated. So you're focusing a trial on essentially what did they foresee, and that draws in terrific bias narratives. That's where language is used in court in a persuasive way, because that's what we as barristers are trained to say, well, they must have contemplated violence because 3 people there had a bat, and there are cases on this where the Court of Appeal have said this is fine, they all contemplated because they're all in it together. So I don't want to go on and on about it, but that language of foresight and contemplation is where all of these narratives are driven, whether it's gang membership, whether it's a woman who is responsible for the behaviour of her violent partner, whether it's an autistic child with challenging behaviour where their past behaviour is relied on a sad character rather than a trait of their condition. So what you have is very, very privileged people. Even if they're socially mobile, they've become King's Counsel, very, very privileged people interpreting within that language of contemplation. And it really broadens the scope for saying, for example, all the schoolboys in that park when there was a fight are all guilty. We've picked the few that we can identify on the footage, so they're obviously guilty. And you might just have a boy in his blazer watching a school fight who is suddenly guilty of murder because somebody's stabbed. And the Court of Appeal has said, really, that's not an overwhelming supervening act because you're all there and you're all in a crowd. So we have this language of contemplation being used to assume that everybody is all in it together, which I think is very objective. And your contemplation and then your knowledge of what the principal party is going to do should be subjective. The law is meant to be subjective, but I think what we end up is an objective assessment of contemplation and knowledge before we even get to contention. intention that is driven by very privileged people who, frankly, in my observation, often sort of genuinely believe they're all guilty without, and are offended if you accuse them of being sexist or racist or lacking in understanding. And so that I think is where the problem is arising. Secondly, it's commonly said, well, we're now convicting all these people because we've got CCTV when we didn't have CCTV. So we're following the footage of the telephone calls, and we can, I would say, assume, they would say infer, that they're all guilty because we've got these phone calls and this footage. But what you don't have now is what you used to have was a witness that said, well, no, he didn't do anything, because very few people are asked to be witnesses in those cases, often because they're all charged. But you don't actually have the human witness evidence that goes to a jury to say, I was there, this person was not involved. You have a very privileged, usually white man, saying, it's obvious they were involved. Look, he's running past a car or cycling. One case that I had on appeal that stays with me is a young black boy cycling, autistic boy, cycling to and from a fight on his bike. Never gets involved in the fight at all. Happens to have a bandana on, so he must be part of the group. And the Court of Appeal refused me leave on that. And regularly I have to look in the faces of the mums. Well, you know, almost every time, is that it? Nobody is listening to this boy, did not contribute to this crime at all. So it's your measure of his contemplation, not his, not mine. And that, I think, is really, really dangerous, that we are giving more value to the opinion of the prosecutor, and it is opinion, than we are to the circumstance itself, the factual circumstance itself. And that's why I think there has to be restraint in terms of some form of contribution. And I think there's a very simple way of putting it, which is, instead of did they intend to assist or encourage, you start with, did this person make a contribution to this crime? Now, quite how a statute would frame that, we could debate, but that to me is the ordinary human experience. It's what a jury understands. So to get back to your question about juries, is that you find yourself having to say to a jury, you know, what did they actually do, when the court is trying to say, well, there is no contribution element, Dr. Gerry, so you've got to be really careful how you try and frame it. You've got to get someone on the jury that sort of gets what you're trying to say. So it's very, very difficult. And that's why I say the jury is a lottery, because I think in the end, what you're asking the jury to do, the contemplation and an assessment of phone calls or text messages, is that human exercise, that moral exercise, is, did they really do anything? And I think that's what juries are probably doing, is, do we really think this person contributed? So we'll give them a reasonable doubt, or we won't. And then it's about how they've been persuaded by my profession. And it really worries me that my profession stand up and make it plain that they want to make it very, very plain that they want to convict that person for cycling to and from a fight, or standing in a group, or we can all think of those examples, you know, looking for her shoes on the floor while there's a fight, pulling someone's hair, punching some other person and not the deceased. They make it really, really plain that they want to convict those people. So that my final worry is that you're saying to a jury, this is the evidence you've got, but we really want to convict them, which I think might risk juries thinking there must be something else in it.
One of the ways, Felicity, and we are, after this exchange, going to go to our audience questions, but one of the ways, Felicity, that you, I think, have tried to stand up is by arguing for narrowing the law itself.
Yes.
And I know that you are one of the pivotal people that were involved in the Joint Enterprise Significant Contribution Bill that was tabled by Kim Johnson a couple of years ago. Just wanted to share with you the government response to that, which was essentially that the law as it stands needs to stay flexible, that juries might not understand the narrower test, and that in itself could lead to disparity in decision making, because what one person in one place, I guess, if they're saying considers significant, might vary from another, and that wouldn't seem fair. Do you buy that as the reason why that legislation
No, what we're
wasn't
doing
taken
now
forward?
is not fair. We're not being precise. We're not focusing on the conduct element. We're bringing together this contemplation in a way that suggests that's a form of conduct. So I don't buy it at all. And obviously I come from a place where I represented Mr. Fiaz in the Court of Appeal, case of Hussein, where I used Matt Dyson's report. It's this terrible judgment where it says, yes, we've read it, but they don't give any reasoning. And they say, first of all, they say it was a big knife, so he must have known the other person had it. And anyway, it's about drugs, so you can contemplate there's going to be a knife there because it's about drugs, which is wild, given that kids, and it was cannabis. It wasn't like it was kids and cannabis. So they make this wild notion that it's a big knife, so he must have known, which means must have known means did know. So that was truly shocking, to stand in the Court of Appeal and find the way that the evidence was being manipulated by the Court of Appeal. And then to sit there and say causation doesn't matter in a case where my client is in the back of a car, nowhere near the scene, around the corner. So he's not assisting. He must be encouraging in some way. What's his assistance? He's sitting in a car around the corner. So if he's encouraging, traditionally that was counselling and procuring, which has an element of causation. So they're sitting there saying causation is irrelevant. So, and I said, all I want is a material contribution. I only asked for, has he made a material contribution to this crime, which I think juries understand. So we're not asking juries to be fair. The Court of Appeal said we're not going to be fair because we're not going to ask a jury, even in an encouragement case, to think about the contribution that someone made to the crime. So obviously I genuinely believe that the problem is so bad now that we need to restore, in many ways, the language of aid, abet, counsel and procure. I understand that, helping, pushing a crime forward, advising someone to do it and procuring the crime. Those all have little bits of causational connection to the crime itself. So in losing the language of aid, abet, counsel and procure, reducing that, if you like, or changing it to assist or encourage, that of itself allows the conduct element to be broader. So it used to be Foresight made the fault element broad. Now we've got the conduct element being so wide that you can pretty much be at the scene doing anything, wave at your mum, you know, and you're on the footage and you're at risk. Look, they're waving. So I absolutely support the idea that we have reached such a level of unfairness and such an obstructive culture of no in the Court of Appeal, including refusing to give leave, so that on cases like Mr. Fiaz's case, I can't get to the Supreme Court, even though I tried, and I told the Supreme Court that the Court of Appeal was being unreasonable and they ought to exercise supervisory jurisdiction, but that's a whole other story. But yeah, so I think that we have a culture of no, we have a culture of utter unfairness, and this framing of people in court by a very, very eloquent counsel.
Okay. We've talked quite a lot, I think, so far about some of the criticisms around those legal channels, less so about, if we turn to politicians, what some of the challenges might be there, but maybe that's something we can pick up in questions, because I do want to make sure that we have time for some questions. I'm going to ask a question that's come in through people who are joining us here tonight online first, and I'm going to come to the room and probably take a couple of questions at once. This is a question from Dr. Becky Clark, and those who know Becky's work, Stories of Injustice is one of the key publications there, will be unsurprised to hear that this is a question about women. Becky says, given the expertise of the legal practitioners on the panel, and to recognise the number of women convicted as secondary parties and the devastation for their children and families, I'd like to hear any reflections for how joint enterprise has contributed to the extension of liability for women in murder trials, where women are responsibilised for men's violence.
Vera, you're currently a member of the Women's Justice Board. Is that on your radar there?
No, but it's very much on my radar otherwise, and not as the chair of the CCRC. but as a person who's campaigned for instance, a defence to some level of crime for a woman who is coercively controlled. You know, there is a direct analogy to modern slavery, a direct one, and there are a couple of cases post the report about grooming gangs. There are some cases which are where a person, a woman, has been groomed by the head of a grooming gang to whom she's married. This, I think, has got some potential. Other cases that might have potential are the re-emergence on appeal recently of the marital coercion defence. Do you remember it? Do you remember way back there? I mean, it's obviously an Edwardian concept that a man tells his wife to do a crime. If he's present, she has a defence. Indeed, it was a presumption in the first place that she had only done it without her own willpower, but through his. And then it was removed as a presumption and it became a defence, which actually, was obviously, it was only for a man against a woman, not the other way around. All of it was made, and it went in the Vicky Pryce, Chris Fu trial, if you remember, when she was convicted of taking his points. That led to its demolition. But interestingly, there are a couple of cases that predated that may yet come up for appeal. And of course, there was a reservation, although the defence was abolished, there was a reservation that if a crime was committed in that time, it could still be pleaded. And again, although that would be, you can't really go back in history and use quite that model, you can see how, if there were a finding that had been an active impact on the woman, how that would relate to grooming gangs, and it would relate to modern slavery, and it would relate to coercive control, and albeit out of time, it could make a good point. So I think there's plenty across the piece, not particularly from me, of creative thinking about how to try to tackle this. But yes, undoubtedly, joint enterprise will have played its role.
I did see the Youth Women's Justice Board recently released strategy that one of the recommendations there is about doing a prison survey of women on very long sentences. So perhaps it's something that could be included in that survey about how some of those women have ended up in those very long sentences. You've been very patient in the room. Can I take some questions that you might have for our panel? I'd just like to signal that you're interested in asking a question. I'll probably take a couple at once. If you want to say, if you're happy to say who you are, then that's always really helpful. If it's directed to anyone in particular, let me know. Otherwise, it might be something very now.
So, Mr. Jogee KC, formerly known as Joint Enterprise. There's a question, but there's something that I just wanted to, going back to what you were talking about the 7-day target to identify, suspects.
Yeah, charge people on murder cases, on homicide cases.
So going back to my son's case, the DC on that case, we had there was 8 boys. So one of the boys that was there, who should have been in the dock, he was used as star witness for the prosecutor. In the end, he basically turned around and was a witness for our children, because he was adamant, as it was said, that they were going to a party. But in that case, it came out that the police had also coerced him to say certain things. And one of the police who had coerced him to say what he, the witness said, there was on lunch, and I know this will be controversial, we heard Rajman Bose, no, I'm going to resign. After this case, I'm going to resign. So he was thinking that these boys were going to be convicted, so he can resign after he gets convicted. So, they wonder whatever case they're going to resign. I say that to say this is that when we used to have a lot of meetings with police, whether it be commission or whether it be somebody behind the police force, and one police said to us that there is a turnaround of every 6 months. there's a new commissioner, because the other ones that will come in from, say that for instance, they're coming from say let's say Belgium for instance, they've come down to Tottenham or they've come down to Edmonton because they heard that it's a really hard place, and if you can get how many rests from, you know, while you're there in that 6 months period, you get promoted to another level. So what I would like to know is, are these joint enterprise convictions incentivized? You know, is it the amount of joint enterprise cases you get, or the amount of people that you can convict? Is it a thing where you're going to get promoted to another level? Because that DC thought he was going to be able to get a conviction by using this style with this. He was going to get all of these boys, and then you can tie all nicely on whatever paycheck you will get.
Okay.
Because we know that these cases make a lot of money.
Okay, so policing around this and the charging around this and what is going on there. I think I'm going to put Patrick first on that, but just stick another question. Give Patrick the time to have a think. There's another question in the room. Javier, kind of like going back to Felicity, because I've always thought the reason joint enterprise keeps going round in circles is because prosecutors can also defend, and like we say, they might prosecute to the hilt because they want that conviction. If they're the same people who are defending, they're not going to be defended very well. So my thought has always been, especially in the joint enterprise case, you're either a defender only or a prosecutor only, and you can then cross over. Do you think that would be a better way forward?
All right, so that's Jan from Gemba with a question about whether we should have quite a substantial change in barristers, and they should only be prosecutors or defenders, but not our current practice of both. Okay, all right. Patrick, I'll come to you first. I know you've tried to, I don't know if get to the bottom is the right term, of policing and charging practices, and I know it could be a very frustrating process to try and do that. What's your kind of response to Phil's question about this? We're back to conviction maximising, I guess.
We're back to conviction maximising, and thanks, Phil. I'm also thinking about the family and the length of time your boy spent on remand, which is again disproportionate impacts young black boys. So that was a really big deal, a number of months in that space. There is that question, isn't there, around targets and a target-driven system. It's not I don't want to get into that conversation. I guess there's something about the constructs and notions of crime and criminality, and the need to be seen to be responding to that. And therefore, who's incentivized and how they're incentivized isn't really my gig. I don't work in the police. I don't really engage in that way. However, we have to recognize, therefore, that even within communities, when incidents happen and when violent incidents happen, then there's a conversation and then a requirement to respond to what has taken place. So we can see why the police may engage in these strategies to maximize the level of convictions in order to secure those convictions. I guess it's acknowledging that piece, but then recognizing that joint enterprise isn't the tool or the device through which to try and secure any notions of justice. And therefore, that's what we need to begin to rethink and begin to respond to. I guess that's how I want to leave that.
All right, brilliant. So to go over to Jan's question, where you're asking about whether we should divide, people can only go into, as barristers, can it be prosecution or defenders? Got a view on that?
I think that would make it worse. Because I like to think that if the barrister had worked defending and being around, these people that are accused of the most serious crimes and getting to know them as people, albeit their clients, if they were to make that move over to prosecution, which is entirely fair, of course they can, then they wouldn't be, there's that element of seeing them as humans in the dock, and tailoring their use of language and being fair around things like how they present a case to a jury is like.
Okay. We've got several more questions to get to. I'm going to go to a few more questions that have come from those who are joining us online tonight. Vera, I think this is one for you. Is it correct that the CCRC are swamped with cases being put before them? And if so, how can the system be improved? Another question, I'll take maybe three from what people are joining us online. Joe Wheeler asks, expert witnesses are another problematic area in joint enterprise cases. Is there any genuine pressure to prevent the police from giving such so-called evidence? So we're talking there about expert evidence from the police, particularly around gangs. And Zara, who I believe is from Kids of Colour, has asked, as somebody who sits through trials supporting young people and families who are on trial in joint enterprise / collective punishment cases, I'd be keen to hear the panel's thoughts about the reality that children and young people are being tried in an adult court, full of theatrics, engulfed in difficult and inaccessible language and practice, but are expected to be able to keep up with the trial process and engage their legal representatives in extremely limited circumstances, holding sales, last-minute legal visits, with intermediaries that often do not live up to expectations. Okay, so a question there about the CCRC being swamped and how we can improve that, question about expert witnesses, and a question there about supporting young people through the trial. Vera, are you happy for me to come to you on the CCRC question?
Can I say a couple more things?
Please.
I think that there is a big problem that special measures which are available for witnesses and victims are not available for vulnerable defendants who would pass the same test. And that's been a crying problem since the Bulger case, actually. And although you can get a little bit of protection for a vulnerable defendant, and by arguing with the judge, you can perhaps get a little bit more, it ought to be the same level of eligibility, I would have thought, so that they can be protected from the same kind of stress and the trauma and so on. So I think there's much to be said about that in terms of protecting vulnerable defendants in the big flashy courts. And of course, I was a big flashy barrister myself, and the description is not.
I like you pointing at me.
Yeah.
I pointed at. I mean, it was cat but, I was as theatrical as can be. It was obviously a different style by then. It was not very formal kind of, but it was nonetheless. There's a lot of drama to it. I accept that. And that must be very off-putting. And it's often, I once had to say to a judge who said something about ipsissima verba, my client deserves to be tried in a language he can speak. And that kind of thing still can happen. So I fundamentally register what's being said, and particularly young people who are, all the more vulnerable. So a good look at how they are protected seems to me to be really important. Can I say also, because we have, I watched the House of Lords debate on Kim's, it wasn't Kim's bill by then,
but in a different form last month.
Just this February, in the legislation that's just passed, I think probably today, and it was the same argument. It was a significant contribution.
That's right.
Was the term of phrase that was used, and that seemed to me to be, a sensible approach to start from, whether it is actually the right word, and to dismiss that saying it will be a value judgment. When people have to weigh self-defense, for instance, on juries, I don't think is that realistic. But my underlying appreciation of what's going on about this is they're waiting for the Law Commission. And so it's just going to go down to that, who won't, I think, report until about 27, 28. So
on current schedule, but then there may be ways to look at that and how joint enterprise might be able to be prioritised, perhaps, in what is a very big piece of work on homicide, Felicity?
Well, that's definitely worth doing if you can try it. I don't know whether that's the way the Law Commission ever works.
Okay, so I'm a trier here. I can't talk about my current case, other than to say certainly there is an application for special measures for a vulnerable defendant. Certainly, we are trying to grapple with what is said in Challen about violence, abuse and coercive control in the circumstance of an accessory. Now we have online meetings with clients. I try and do it as often as possible, sometimes every week. I don't know if I'm a rarity or not. I haven't done the research on what other barristers do. I am a bit of an outlier, I think. And I do think you have to put your client's interests ahead of your collegiality at the bar, which doesn't make me everybody's friend, which slightly answers your question. I used to prosecute. I like to think I would be fair if I prosecuted, but I haven't done for years and never enjoyed enterprise. I think I'm very encouraged by what the Law Commission are saying so far. For example, I've long argued that we should audit the prisons, find the people who were wrongly convicted under the foresight test, create some sort of panel that recognises who was convicted on a foresight test, and frankly get them out, which includes Alex Henry. And what the Law Commission have said is that they can't find that the substantial injustice test has any legal foundation whatsoever, which of course I've banged on about for a very long time, including to the Court of Appeal, who took no notice of me. I genuinely think when you look at the law as it developed correctly, there is a causation. I think causation is the hardest thing to grapple with in law, but it's there, and contribution is something we have to grapple with, because that's where your culpability comes from. You know, this comes back to basic jurisprudence that we're trying to find. Who is a criminal? What is a crime? It's week one criminal law. So I do think there's something about contribution. I don't have an issue whatsoever with the word significant. I might have something to do wrong, but so I think there are also some really good noises around from the Law Commission around sentencing. So there's an understanding that we are convicting people who make no significant contribution to a crime, and they are receiving a mandatory life sentence with a minimum term of 25 years. And bear in mind, the Court of Appeal said it doesn't have to be them that takes a knife, so long as someone takes a knife to a scene. So where the words are, you're going to be sentenced for taking a knife to the scene, that's now been interpreted if anyone takes a knife to the scene, not just you. So there are some terrible interpretations by the Court of Appeal that I think have made people suddenly realise, well, hang on, how come these kids are in prison for labelled as murderers when they make no significant contribution to the crime, but they're facing, and prosecutors are choosing to prosecute them for that crime without an alternative, or without a meaningful or realistic alternative, so that they know when they're charged that they're going to be facing life with a mandatory minimum term. I think the world is waking up to the fact that sentencing is an area that must be changed, and that the Law Commission is already making some significant comments about that. I'm not saying the Law Commission is the answer, and I certainly don't want to wait till 2028. I think it's really obvious now. I think the other thing the Law Commission are talking quite well about at the moment, from what they're writing, is this idea that we can't get to the Supreme Court if the Court of Appeal is refusing leave to appeal. I work in Australia, and there's a special leave application system. You write, I mean, I did it in joint enterprise and they said no, but I did write for a special leave to the High Court of Australia, which is the equivalent. So it's not good enough, it's not fast enough, it's not fair, it's failing to have regard to basic humanity. We have people in prison who are, I believe, suffering as a result of what we're doing. I think someone called it to me the other day a civil death. So we're subjecting people's children to a civil death. Their lives are gone. They spend, God knows whether they'll ever get out. And I find that appalling. So we have to do every little bit we can to see, as I do, that these are people's children, sisters, brothers, mums, that the threshold test of charging people is wrong and draconian, not bailing people is wrong and draconian, and not really being upfront about, particularly, I'll come back to your vulnerability point, is what we might call victim perpetrators. These people who are multiple victims of abuse, violence, coercive control, not just women, children as well. Children who are exploited in criminal gangs, for example, when there is a genuine organised criminal gang, who are then put forward and rounded up and part of a joint enterprise murder case, with one of which I had to run, where, of course, the human trafficking defence is not a defence. So there's a piece of law that we could do, change Schedule 4 of the Modern Slavery Act to remove the restriction when it applies to an accessory. can we say that this person is an accessory who's being exploited to be present? And if so, don't prosecute. And I think what's interesting about human trafficking is there's an emerging right not to be prosecuted for very vulnerable people. And the language is as wide as abuse of vulnerability. And in most of the cases that I've seen, definitely people are vulnerable for all sorts of different reasons. And their vulnerability is abused, not just by the people on the ground, but I believe by the state. So I think people are suffering twice. Once at the hands of the people that abuse them on the ground. That might be a woman in an abusive relationship whose partner commits a stabbing, for example. It might be children used in drug running or locked in as gardeners where a fight occurs, those sorts of cases. So once we understand that language, then we can start to see how unbalanced our criminal justice system is and why it's really, really important to rebalance the scales, if you like. So I think, and just to give you an example that is not murder, just for the sake of argument, because we always get, we're always banging on that. We can't treat murder separately, and I never would. I think this is across the board. That restriction in the Modern Slavery Act applies to human trafficking itself. So you can't run the human trafficking defence if you're charged with a human trafficking offence. And yet we all as humans understand that trafficked people exist in traffic networks. So to come from that point, we understand that kids are often in a network of people where they just don't hold that criminal responsibility. They're not criminals, they haven't committed a crime. They're just on a piece of footage. So those are that's a sort of mix of emotive and legal issues for everybody to think about. I think there is some noise. I'm very pleased to hear Vera hasn't lost her ability to make a noise like she did at the bar, accepting that she can't speak specifically about the CCRC, but these issues are out there. They need to be understood. And I think there are some people in important places like the Law Commission, not only the Law Commission, have at least agreed with me a bit.
All right, we've got the other two questions that were asked online, and then I'm going to come back to the room. Zara's question about young people and their support through trials. Would anyone like to say anything on that?
So I worked with the Advocates Gateway for years and wrote toolkits. I now publish on trauma-informed courts. Justice, of course, reported that we shouldn't have the glass dock. No children should be in the courts that I appear in. The Old Bailey is a disaster. It's shocking what we do to children.
Okay. And Joe's question of expert witnesses, is there any genuine pressure to prevent the police from giving such so-called evidence in Gara's case?
No, they give their opinion on what's happening on the CCTV.
Yes, right, we've got big answers there. I want to come back to the room because I saw some hands go up and we haven't got lots of time remaining. So I can see 3.5, I can see 4 hands up. Okay, Gus, I'm going to come to you first, the back of the room.
Yes, my name is Gus John. Until recently, I was chair of a charity, which I started with some others in 1999 that deals with school exclusions. And in that period that Patrick reminded us about, just after the 2011 civil unrest in Tottenham, following Mount Douglas killing, there was a spike in the number of school exclusions that we were asked to deal with. And that was because Bernard Hogan Howe, Rambo style, decided that he was going to take the war as he saw it to the gangs. And lots of young people who were not associated with gangs, they may have been siblings of people who had been identified as gang members, were being targeted by not just the police, but by the gang matrix people who sent information to head teachers about those young people. Massive injustices were being done at the time. And in fact, Amnesty International did a report, which you would know about, Helen. And we use that a lot amongst parents and advocates and so on and so forth. The point I'm trying to make about that is this. Stafford Scott of the Tottenham Rights Group. He called that whole stuff that was going on then a war on black youth. But it's a war that started many decades earlier. When I worked for the Renemy Trust in Handsworth in Birmingham in 1969, we had to set up little groups, patrol groups, which we called policing the police groups. And we went around, we had no mobile phones at the time, but we were actually monitoring what the police were doing with those young people on the streets of Handsworth in 1969. And that, it sort of traveled into the way they were being treated in schools, what were going on in the juvenile courts, and so on. Roll on 20 years, or even less, we were having to struggle against sus and all of those convictions that took place as a result of sus activities by the police. And common to all of that, of course, has been stop and search. And of course, the business of police in schools. So my question really, having all of that as historical background, is this. We all know that the level of political literacy amongst school students is abysmally low, right? We know that the schools don't address those kinds of issues in the curriculum. And yet there is a whole generation, well, more than one generation of young black people growing up with these injustices, systemic, as we're discussing here now, in relation to the criminal justice system. And there's very little discussion amongst them themselves about it all. So my question really to the whole panel is, how do we ensure that young people themselves are gaining the consciousness of those issues which have to do with, it speaks to the condition of being young and black in British society.
Okay, all right. Okay, great. So how do we raise consciousness within communities?
Yeah, and amongst young people themselves.
And amongst young people themselves.
So that they can use their own agency.
Okay.
In tackling these issues.
Okay, great. Thank you, Gus. Glo, I can see you've got a question, and then I'll come to Ray in the front, who's also got a question.
Yeah, my question is well, thanks very much for this report, Helen, and the Centre for Crime Justice. It's really important. It's kind of for Patrick and for yourself. One of the things that we're quite aware of is that obviously Gemma is sitting on the most extensive data of joint enterprise because we've, you know, as you guys have used a lot of our data, but we'd really like to know the amount of young people particularly, it doesn't have to be young people, but because they're vulnerable, that are, because Peggy Clark raised this when we were on the scrutiny panel and she got really shouted down by the CPS. So Becky Clark asked them about deals, plea bargaining, and they absolutely were adamant that they do not do plea bargaining. They were visibly angry about that. So we would like to know, is there any way research could then get to the bottom of, because basically, I know it's not quite coercive control, but if you've got a group of young people and you're saying to them, if you don't take a manslaughter, we're going to go for murder. And we know we've got cases. We know we've got cases where they've got, there has been, time immemorial, we've got cases where they are bullying them to take a lesser plea so that they can get them for something. And I think that would be quite key, that piece of research, if you could find out how many people are serving manslaughter joint enterprise charges. Because it's not really thought about. We think the murder and you think, oh, well, if they, you know, it's not so bad because we do it now. Right? We're getting cases where young 17-year-olds are getting 23 years. So if you get someone who's got a manslaughter, think, oh, that's okay, because they're only going to do 9, and you know, it's not so bad. It's still wrong. It's fundamentally, it's wrong. It's an abuse of the law to get convictions, which we know, that's exactly what joint enterprise is. But is there any way of doing research into that you could look at how many manslaughter cases under joint enterprise, you know, how many, you know, the data behind that? Because I think that would be really revealing. It'd be really telling on those kind of convictions that are still sending innocent young people to prison.
All right, thank
you. Any manslaughter pleas that we didn't go to trial.
Thanks, Gloria. I definitely felt in the room that lots of people chimed for their experience about the existence of plea bargaining in young people. Okay, so maybe people on the panel are happy to speak to that issue or their experience of it. Ray, you've got a question.
Yeah, well, a couple of quick points. Following up what people have said. In 1980, I was working for an organisation in Camden, and one of the things we ran was a motor repair shop, and there was a break in there. And the police officer came down and said, could you give us a list of the people who are doing the training here, and could you put a cross against all the black ones? And I said, you do realise we're the Race Relations Committee for Camden here, so sod off. But that was 1980, and before that it always was. On comments about victims, young people who are victims, this is really depressing. The other day, the Commons Justice Committee were questioning 3 representatives from, one from Young Offenders Institute, one from the Secure School, and one from the Secure Homes. And one of the MPs sat there as they were talking through the abuse, sexual and physical, and the grooming that some of these young people have been through, is why they ended up there. One of the MPs actually said, no, we should be talking about the real victims. And what chance have you got when someone on the bloody Justice Committee talks about real victims? But my main point was, it comes home from Pearl, I know. I was going to say, I talked to Pearl, I listened to Pearl, and wrote about her son's case. And that was where a jury saw through the case, and he was found not guilty. But we don't read enough about those. Now, if the people on a jury are ordinary people, they sit at home, they watch the TV, they read the paper, and all they see, group of convicted of this knife crime group, they don't actually hear of cases where juries have seen through the case and argue against it. And I think we've all got a duty to push those cases through and say that a lot of these charges are just false. I mean, we've got loads of reports that justify that and prove that, but they don't get talked about. And when a case starts, the first couple of days the newspaper headline it and go through it, and what you hear is so-and-so did this, so-and-so did that. And that's because that's the prosecution case. So you read the prosecution case, and you're absolutely convinced, sat at home, well, he did that, he's guilty. Because you don't see the defence case, because they don't interest. And if the person's acquitted, you don't hear about it at all. If they're convicted, they're headline news. And I think there's a duty on all of us, and I write for Inside Times, so I suppose I would think this, to actually make those points that people are wrongly accused, and juries do see through it if they had the opportunity to do that.
Great, thank you, Ray. We haven't got very long left to respond to those questions and just do a kind of final summing up really from our panel, but just a quick shout out, if you do want to read some stories about where juries do acquit, there are 2 of them in the Centre for Crime and Justice Studies' latest report called Joint Enterprise, A View Over Time. And in particular from someone who was sat doing observation of a trial where she can talk through what the prosecution's case was, and in another from the family of the young boy who was being prosecuted for a murder. Okay, there's a lot there. I'm just going to remind you of the 3 questions and maybe ask the panel to pick them up if I can. There was a question there on communities and how we can encourage young people to get involved in this, and communities being able, I suppose, to raise their own power to this. Patrick, I imagine you're going to have something to say about that. There's Gloria's question about plea bargaining, which, as I say, got a real response in the room if anyone's prepared to speak about plea bargaining. And there is Ray's question around the whole real victims argument, which Vera, as a former victims commissioner, you might have something to say about. So those 3 things, would anyone like to pick up on any of those?
Certainly when
Vera?
I was at the bar, there was plea bargaining all the time. So I'm not giving any secrets away. And I'm surprised that the CPS say it doesn't exist. It may be extinct, but that's not what I know. And it would be very interesting, because I think that a lot of people, a lot of young people are persuaded that being convicted of murder is so terrible that manslaughter, which doesn't have an infinite sentence, is a lot easier. And that must be a massive pressure on a young person who could just, foresee possibly, a sentence of 5 years and coming out the end of it, but just can't see the possibility they're convicted of something worse. So I can see massive pressure there. And, you know, I don't want to comment about why it's done, but sometimes I'm pretty sure that it's done in the belief that it's in their interest. You know, the advice is given on exactly the basis that it's received. But I'm sure it doesn't. It really can't have stopped, I don't think. I agree with Ray about having a duty, as it were, to make clear that people are wrongly accused or that people are acquitted, that juries don't accept what's happened. I also think we've got to do a great deal more, and I hope that we can help with this, to make sure that we've got to try and stop these guys being convicted in the first place. And the counter narrative to this gang narrative has really got to, there are plenty of experts now, aren't there? I've seen a list of names you've mentioned, Becky, a whole range of other people who are capable of coming into court and negativing, much of what he said about gang narrative. I don't know how it goes, Felicity will, because it looks like bad character evidence to me. Yeah, is it applied for as if it were bad character evidence? Yeah, okay, so it's very clear that what they're saying is if you're a member of a gang, then it's as if you've got a previous conviction. It's bad character, so you're stigmatized in the first place. But I think that is, in fact, however it's technically done, is how it works. And you've then got to argue your way out of that. And if you've got some good academics on your side coming into the witness box saying, no, actually, this group was about music, and this video that I've seen, it's about music. And, lots of kids age 15, 16 make funny signs at one another. Goodness me, let's not mention the Freemasons. They do it when they're not. So I just think, what we really need to do is to generate some energy around a counter narrative for those cases. You did ask me if we were overrun, and I didn't reply. We're not. We're very, very busy. 1,800 applications this year, about 200 more than we had last year. And although we're trying to recruit new case review managers, we definitely need a lot more of them. So that's the reality. But there are prioritizing criteria, which I hope are very humanely faced. And I, by the way, we never prosecuted. Like Mansfield's Chambers, or the Radical Bar as it was then, never prosecuted. I have to say, we were rarely asked to prosecute. And I did prosecute for Greenpeace once, and also on behalf of the TGWU, as it then was, for some traffic wardens who get pushed about by people because they put a ticket on their car. But that was the limit of anybody in Tooks Court, Garden Court, or Doughty Street's experience of prosecuting.
Brilliant, thank you. Last comment from a panel in response to a question. Patrick, do you want to come back on Gus's question?
I did want to come back on that. It's an extremely important. Thank you for the history and reminding us of that history, Professor John. It's key in terms of how we begin to reinvest back into communities, and not even reinvest back into communities, but almost recognise that the community often has solutions for the harms and the problems that they are experiencing. And it's based on some of those initiatives and ideas and ways of working that you were speaking to there that we almost need to begin to move back towards. And I'm doing some work with folks in Manchester, but also nationally around harm to healing. And it's how do we begin to starve this system of attention? How do we starve it? Because essentially it is about how do we stop young people getting to the courtroom? Because once they're in there, they do not stand a chance. So how do we stop them getting to the courtroom? And I guess that's the initiative and drawing on those old examples that we really need to get back towards. Otherwise, we'll be here in 10 years' time speaking to the same issues.
Brilliant. Thank you, Patrick. Good point to finish on. We are over time for this evening. I want to thank everybody who has been with us tonight, including obviously our panel, for the care and seriousness that you have given this discussion. We've not necessarily had some brief responses, have we? But maybe that is what you get when you ask for some honesty and insight into what are very complex issues, and people come at this from a range of perspectives. I just want to remind everybody that this should not mark the end of a conversation. Still ahead in upcoming months, we've got the Court of Appeal cases. The Westminster Commission report is due to report, I believe, in autumn this year, which has been scrutinising joint enterprise laws and practices. one to look out for. And there is, of course, the ongoing work of the Law Commission. Much of that will shape, I think, what happens next. Thank you so much. I'm delighted such a variety of people were able to get into the room and join us online tonight. Thank you so much for that. Particularly like to thank Rory and Mimi who organised this and have made the tech go without a hitch, right? It's a thumbs up. Okay, great. Thank you. Thank you for joining us online and thank you for joining us in the room.